When you're out for mischief, you would enjoy it. When you're out for mischief, when you want to achieve an ulterior motive, it's likely because some of the cases are not such that people can't sit down and resolve. And then you see people go all the way to the Supreme Court, come back and go all the way to the Supreme Court, and sometimes over nothing.
And this concept of go to court, it's a very bad.
No, it is a very bad statement. Because you see, if you look at the arrogance with which those who make that statement make it, you sometimes will not be blamed for going away believing that they make that statement because they are confident that they have an idea of what the outcome would be. And no judicial process should be viewed in the light that people may already not have an idea what the outcome would be. That there may not be fairness, that the man is just daring you to just go there and waste your time. It may not necessarily be the situation, but that is perception they give when they say go to court. So it's more like might being right. Just get yourself declared winner, win, then let them go, and waste their time. We're already here. We'll defeat them still. All of us. The lawyers who see these provisions and still go to court. The judges who see this and waste so much time instead of asking parties to address it. Do I have jurisdiction in the light of this position? One of the things you're taught as a law student is that law is in the bosom of the judge. So the judge is presumed to know the law. Yeah. And a judge, having read the papers filed before him, said, look, this matter is not about internal crisis of a police. Can you address me on whether I have jurisdiction? And we don't have to waste so much time. And that section also talked about such matters being heard quickly. Accelerated hearing. Expedited hearing. And we're not getting that. And orders are made. And there are strict timelines for the doing of certain things. And the matters are pending. So, of what use will a decision rendered after those timelines are passed? What use is making of an order that creates confusion as to what that status quo really means?
Let us see.
Or makes the compliance of that difficult, left in interpretation of all the parties and the whims and caprices of those who are involved.
Let us see. Exception is a very fundamental principle in law practice. Are there exceptions to where courts can intervene in inter-party dispute?
Well, I wouldn't know. If you look at the statute, it would appear that there isn't in internal crisis. But when it talks about who is the candidate representing a party, the primaries, the court would have jurisdiction. And the whole essence, if you ask me, is to reduce the number of political cases that go to our courts. In the next few weeks, our courts will be clogged by political cases. And many judges will only be hearing political cases. And this is a country that has rising litigation, where the time it takes to file a case till you get judgments is increasing. And then all these things will snowball into appeals that may end up at the doorsteps of the Supreme Court. So the less the number of cases that get instituted in our courts that our judges are involved in, the less the pressure of work on them, and also the temptation for people to try to corrupt the judicial process to have their way. And essentially, the negative perception of the judiciary at the bar will maintain arise more from political cases than from commercial transactions. It's very explicit. If you look at Section 83, it says that no court shall exercise jurisdiction with respect to internal affairs of a political party. And the section went on to say that where an action is commenced in negation of this provision, that the court shall not make any interim order of injunction or interlocutory injunction, and should leave everything to the final determination of the matter. Now, in prefacing your question, you made reference to where matters are settled. And it's unfortunate that lawyers and courts pretend not to know that certain factual situations have been decided by the courts, the apex court, so that there is nothing new to be decided. While I will not use the example that you have given, and I will use the example of where a member of the executive, say governor or deputy, changes party. You see people litigating it as if it's a new thing. While as far back as 2006, in the case involving Atiku Abubakar, who was then Vice President to Olusegun Obasanjo, the Supreme Court had made it very clear that losing one seat only affects a member of the legislature and not the executive. And yet people still go to court and court make judgments that are not in line with this decision of the Supreme Court that I've referenced. And it shows you either the lawyers have been mischievous or pretend not to know what they do, because I doubt if they don't know it, or the judges who may write such judgments are corrupt or incompetent. And our disciplinary process should work both against the lawyers involved in these actions and the judges Who gives such who makes such decisions?
I mean, in this sense, what happens, Mr. President, where there are disputes as to the leadership of a political party? Yes, there are decisions made by a group in the party, but yet there are unresolved issues and there are disputes generating from such. Where do they go?
So the courts and the INEC should have a dispute resolution mechanism for this. And the parties should have it as a part of the provisions in their constitution. The law as it is that the courts do not have jurisdiction and should not also, where people have shut their eyes to these clear provisions of the law, the courts should not grant any order of injunction. And this brings me to a point which you did not raise, but which I would like to raise. And I also think, considering the confusion that is arising in our body politic in recent times, our courts should not make such orders as using Latin maxims like
status quo,
ante bellum or status quo pendelitis. The court should make clear orders to what it means, so that
there's no ambiguity.
There's no ambiguity. I see situations where people go away rejoicing that the order was in their favor, now giving room for mischief or for anybody to interpret it the way they want. Where a court has chosen to make an order, it should clearly what it has set out to do, and not hide behind any Latin maxim. Seeing that in some other climate may not be a problem, but it seems that we have a peculiar situation in Nigeria where we choose to interpret laws the way it suits us. They're also leading to confusion. Because if the court means the person that was there before coming to court, or the person that make it clear,
even with names,
and instances, so that when people go away, there will be no doubt as to what the court has ordered.
Status quo ante bellum is one guy that if some politician catch today, they will strangle him.
Because he creates confusion.
Status quo ante bellum is a major problem in our politics today.
We rendered it meaningless. Yeah. It's been gutted of any meaning.
Yeah.
So our courts should avoid using such phrases and specify what orders they are making, so that nobody will be left in doubt, or no administrative body would have to interpret it and then try to give his own decision on it.